Hello, my dear students. Today, in label of first paper, we'll talk about compensation for layoff given under Industrial Disputes Act 1947. We'll also talk about the transfer and closure, and we'll talk about the compensation to workmen in case of transfer of undertaking. So we'll take up these topics in this video lecture 36. And all these topics are given unit 4 for BA LLB and BB LLB program under Industrial Disputes Act 1947. So my dear students, first of all, we'll talk about the provisions, special provisions relating to the layoff, retrenchment and closure in certain establishment, which are given under chapter 5th. And this chapter 5th B, in fact, was added in the Industrial Disputes Act 1947 through amendment under Article 32 of the Constitution. And this chapter deals with the special provisions relating to layoff, retrenchment, and closure in certain establishments. First of all, we would try to learn about the meaning of layoff. This term layoff, it has been defined under Section 2KKK of the Industrial Disputes Act 1947. Thus, layoff means the failure, the refusal, or the inability of an employer on account of shortage of coal, power, or raw material, or the accumulation of stocks, or the breakdown of machinery, or natural calamity, or for any other connected reason to give employment to a workman whose name is borne on the establishment on a must roll and in his industrial establishment, and who has not been retrenched. So, my dear students, when an employer is showing his inability, his refusal, and denying to provide the employment to the workman due to these reasons, because of failure of the maybe the power, or there is a means disruption in the supply of the raw material maybe. So with these reasons, if the employer is showing the inability and unable to provide the employment to the workman, and the workman, the name of the workman is borne on the must roll of the industrial establishment and who has not been retrenched. Thus, the following are the essentials of a layoff. There must be failure, refusal, or inability on the part of the employer to give employment to a workman. So this failure, refusal, or inability on the part of the employer to give the employment to the workman, and this failure, refusal, or inability should be on account of the shortage of coal, power, or raw materials, or accumulation of stocks, or breakdown of machinery, or natural calamity, or any other reason connected to that. The workman's name should be on the must rolls of the industrial establishments. The workman should not have been retrenched. Means if the workman has been retrenched, then means will not count it for a layoff, and the workman's name should be borne on the must rolls of the industrial establishments. So these are the essentials of a layoff, that the employer is showing the inability or refusing or showing the failure that he is not able to provide the employment to the workman. And this failure, refusal, or the inability should be on account of the shortage of coal, power, raw material, or accumulation of stocks, or breakdown of machinery, or natural calamity, or any other connected reason. The workman should be on the the name of the workman should be on the must rolls of the industrial establishment, and the workman should not have been retrenched. Then there are certain special provisions relating to the layoff, my dear students, and section 225M imposes a provision of layoff as clause 1 says that no workman other than a badly workman or a casual workman whose name is borne on the must rolls of an industrial establishment to which this chapter applies shall be laid off by his employer except with the prior permission of the appropriate government or such authority as may be specified by that. So if the employer is going for the layoff and the workman whose name is born on the must rolls of an industrial establishment, and to which this chapter applies, and the employer should obtain the prior permission from the appropriate government or such authority as may be specified by the provisions. And government by notification in the official gazette thereafter in the section referred to as a specified authority obtain the appropriate government by notification in the official gazette obtain on an application made in this behalf unless such layoff is due to shortage of power or to natural calamity, and in case of mine such layoff is due also to due also to fire, flood, excess of inflammables gas or explosions also. So in case of mine these provisions would be applicable. And an application for the permission under subsection 1 shall be made by the employer in the prescribed manner, stating clearly the reasons for the intended layoff, and a copy of such application shall also be served simultaneously on the workman concerned in the prescribed manner. Where the workman, other than Badli workman or a casual workman of an industrial establishment, being a mine or have been laid off under subsection 1 for reasons of fire, flood or excess of inflammable gas or explosion, the employer in relation to such establishment shall within a period of 30 days from the commencement of such layoff apply in prescribed manner to the appropriate government or the specified authority for the permission to continue the layoff. So, in case of mine, these provisions would be applicable, and it includes the reason for fire, flood, excess of inflammable gas, or explosions. And where an application for permission under subsection 1 or subsection 3 has been made, the appropriate government or the specified authority, after making such inquiry as it thinks fit and after giving a reasonable opportunity of being heard to the employer, the workman concerned, and the person interested in such a layoff. So, the means when there is an application for the permission under subsection 1 or subsection 3, appropriate government or means to whom any other means in case is the the specified authority is being addressed, then after making such inquiry as it thinks fit, appropriate government or the specified authority, after giving a reasonable opportunity of being heard to the employer. So employer would be provided an opportunity to represent the request, represent the application, and the workman concerned will also avail this opportunity to present the case, and the person instructed in such layoff would be provided an opportunity to represent the case. Means why do they want to go for the layoff? Workman, I beg your pardon, why the employer wants to go for the layoff? The employer will represent the case, the workmen's will also just represent what do they want to say, and the person interested in such layoff will also be sharing the why they would be affected by this layoff. And having regard to the genuineness and adequacy of the reasons for such layoff, the interest of the workman, and all other relevant factors, by order and for reason to be recorded in writing, granting whether the layoff is being granted or refused to grant such permission, and a copy of such order shall be communicated to employer and to the workman as well. So, having regard to the genuineness and adequacy of the reasons for such layoff, the interest of the workman, and all other relevant factors, by order and for reasons to be recorded in writing, grant or refuse to grant such permission, and a copy of such order shall be communicated to the employer and the workman also. And an order of the appropriate government or the specified authority granting or refusing the grant to grant the permission shall, subject to the provisions of subsection 7, be final and binding on all the parties. So whatever decision is being taken by the appropriate government or the specified authority, my dear students, that would be the final and binding on all the parties concerned and shall remain in force for 1 year from the date of such order. So means this order would be final and binding. And then the subsection 7 says that the appropriate government or the specified authority may either or its own motion or on application made by the employer or any workman review its order granting or refusing to grant permission under section 4, or refer the matter or the case may be cause it to be referred to tribunal for adjudication, provided that where a reference has been made to a tribunal under this subsection, it shall pass an award within a period of 30 days from the date of such reference, my dear students. And if you talk about the subsection 8 of this section, then where no application for permission under subsection 1 is made, and where no application uh, uh, for permission under subsection 3 is made within the period specified therein, or where the permission or any layoff has been refused, such layoff shall be deemed to be illegal from the date on which the workman had been laid off, and the workman shall be entitled to all the benefits under any law for the time being in force as if they had not been laid off. So permission is a must, and I beg your pardon, the application for permission is a must under subsection 1, or where no application given under subsection 3 is made, then within the specified period, then uh, or where the case is that permission for layoff has been refused, such layoff shall be deemed to be illegal from that date on which the workman had been laid off, and the workman shall be entitled to all benefits under law. Now, my dear students, we talk about the subsection 9, which says that notwithstanding anything contained in the foregoing provisions of this section, the appropriate government may, if it is satisfied that owing to such exceptional circumstances as accident in the establishment or death of the employer or the like, it is necessary so to do, by order direct that the provisions of the subsection 1, or as the case may be subsection 3, shall not apply in relation to such establishment for such period as may be specified in the order. So if it is satisfied that exceptional circumstances, there may be any accident in the establishment or death of the employer or the like, then it is necessary so to do by order direct that the provisions of subsection, or as the case may be subsection 3, shall not apply in relation to such establishment for such period as may be specified in the order. So this is on available, this advantage or benefit is available to the employer for exceptional circumstances only, as I mentioned, that for during the accident or maybe the certain contingency or exceptional circumstances only will allow this to the employer. And the provisions of section 25C other than the second provision thereto shall apply to the case of layoff referred to in this section. So this is about the subsection 10. Now, my dear students, we talk about the compensation part, compensation for the layoff. So for the layoff of compensation is concerned, it is equal to 50% of the basic salary and dearness allowance, and it is payable to all employees who have completed at least 1 year of service with the company, and total of or the with the company or the establishment, and total of 240 days of work, including paid holidays, uh, paid leaves, and leaves due to employment injury shall constitute a year of service. My dear students, I repeat that layoff compensation is equal to 50% of basic salary and dearness allowance, and it is payable to all employees who have completed at least 1 year of service with the company. Total of 240 days of work, including paid holidays, paid leaves, leaves due to employment injury, shall constitute a year of service. And Now, my dear students, we talk about the closure. The Industrial Disputes Act 1947 originally does not contain the provisions relating to the closure of an industry according to Section 2cc of the Industrial Disputes Act. And closure of or closure of an industry means the permanent closing down of a place of employment or part thereof. And Section 25O, which talks about the procedure for closing down an undertaking, subsection 1 says that an employer who intends to close down an undertaking of an industrial establishment to which this chapter applies shall in the prescribed manner apply for prior permission at least 90 days before the date on which the intended closure is to become effective, and to the appropriate government, stating clearly the reasons for the intended closure of the undertaking, and a copy of such application shall also be served simultaneously on the representatives of the workman in the prescribed manner, and provided that nothing in this subsection shall apply to an undertaking set up for the construction of building, bridges, roads, canals, dams, or other construction work, subsection shall apply, will not apply, right? And where an application for permission has been made under subsection 1, the appropriate government, after making such inquiry as it thinks fit and after giving a reasonable opportunity of being heard to the employer, the workman and the person interested in such closure may, having regards to the genuineness and adequacy of the reasons stated by the employer, the interests of the general public, and the other relevant factors, by order and for reasons to be recorded in writing, grant or refuse to grant such permission, and a copy of such order shall be communicated to the employer and the workman. So, this is one more provision. And subsection 3 says that where an application has been made under subsection 1 and the appropriate government does not communicate to the order regarding the grant or refusing to grant permission to the employer within a period of 60 days from the date on which such application is made, the permission applied for shall be deemed to have been granted on the expiration of said period of the 60 days. So, if the government is not, or the appropriate authority is just not responding, means from the date on which the such application was made within the period of 60 days, not responding, then the permission applied for such shall be deemed to have been granted on the expiration of the set period of 60 days. And subsection 4 says that an order of the appropriate government granting or refusing to grant permission shall, subject to provision of subsection 5, be final and binding on all the parties and shall remain in force for 1 year from the date of such order. And my dear students, subsection 5 says that appropriate government may, either on its own motion or on the application made by the employer or any workman, review its order granting or refusing to grant permission under subsection 2, or refer the matter to a tribunal for education. My dear students, just to recall, I'm mentioning this, that we are talking about section 25O, in which we are talking about the procedure for closing down of an undertaking, and we have discussed several subsections in this head. And now we talk about that, as we were talking about, the reference has been made to for the adjudication, and provided that where a reference has been made to the tribunal under this subsection, it shall pass an award within a period of 30 days from the date of such reference. And subsection 6 says, my dear student, that where no application for permission under subsection 1 is made within the period specified therein, or where the permission for closure has been refused, the closure of the undertaking shall be deemed to be illegal from the date of closure, and the workman shall be entitled to all the benefits under any law for the time being in force, as if the closure undertaking had not been closed down. And subsection 7 says that notwithstanding anything contained in the foregoing provisions for this section, the appropriate government may, if it is satisfied that, owing to such exceptional circumstances as accident in the undertaking or death of the employer, or likely to necessary so to do, by order direct that the provisions of subsection 1 shall not apply in relation to such undertaking for such period as may be specified in the order. This is for exceptional circumstances only, right? And subsection 8 says that where an undertaking is permitted to be closed down under subsection 2, or where the permission of the closure is deemed to be granted under subsection 3, every workman who is employed in that undertaking immediately before the date of application for permission under this section shall be entitled to receive compensation, which shall be equivalent to 15 days average pay for every completed year of continuous service or any part thereof in excess of 6 months. And so far the compensation to workmen in case of transfer of undertaking is concerned, my dear students, we discussed this point under section 25FF, and section says that where the ownership or the management of an undertaking is transferred, uh, then whether by agreement or by operation of law from employer in relation to that undertaking to a new employer, every workman who has been in continuous service or for not less than 1 year in that undertaking immediately before such transfer shall be entitled to notice and compensation in accordance with such with the provisions of section 25F, as if the workman had been retrenched, will be entitled to get that compensation, provided that nothing in this section shall apply to a workman in any case where there has been a change of employer by reason of the transfer. If clause A, the service of the workman has not been interrupted by such transfer. Clause B, the terms and the condition of the service applicable to the workman after such transfers are not in any way less favorable to the workman than those applicable to him immediately before the transfer. And clause C says that the new employer is under the terms of such transfer or otherwise legally liable to pay to the workman in the event of his retrenchment compensation on the basis that his service has been continuous and has not been interrupted by transfer. So this is all about the compensation in case of transfer of undertaking. So, my dear sir, we have discussed clause A, B, C. So this is all about for today's lecture, my dear students. We have discussed 25FF, 25CC, all these sections we have just gone through. And we have also learned that what is the meaning of layoff, what are the conditions for layoff, what would be the compensation for layoff. So all those topics we have covered today, my dear students. I hope this lecture will help you. Thank you so much, and we'll take up some new topic in our next lecture. Thank you so much. Have a nice time. Have a nice day. Take care. Be safe and stay safe at your home. Thank you so much. Bye and take care.